So, Chris, we're going to have this conversation. My name is Mike McKinley. I'm an elder law attorney. And your name is?
Chris Ramsey.
Chris Ramsey. And you are my marketing coordinator slash scheduler slash organizer, do-it-all type person. So, the purpose of this video series is going to be just pure educational. We're going to try to address questions that you get a lot, that I get a lot, misconceptions, myths, etc., that we run into in the elder law practice, and is doing legal work for anyone over the age of 65. There's a lot of misconceptions out there. A lot of Google lawyers that get it wrong. A lot of actual lawyers that get it wrong. It's shocking how often I run into people who claim to be estate planning attorneys who are giving completely wrong advice. So let's start with that. So would you like to introduce yourself and tell about what you've done in the past or anything like that? Come on now, don't be shy.
My name is Chris Ramsey, and my background is I'm an occupational therapist. So I've worked with seniors in some capacity for about 30-some years. So I have a real heart for those seniors. So they like to talk to me. If they don't get all the heart from Mike, I'm happy to give them all that attention. So, but do find it really interesting what Mike does do for our seniors and for our clients, and a few questions that I am asked often that results in them scheduling consults with Mike. And the first one being, what is a POA?
Okay, so a power of attorney is often very misunderstood document. It's more, all that is a document that says, if I'm unable to speak, you speak on my behalf. It does not give you the power over me. Okay, so if you're my power of attorney or my attorney in fact, which is the technical term, it doesn't mean you can make me do something that I don't want to do. You don't have the right to take my money, and there's things called fiduciary duties, which means if you're acting on my behalf, you have to act in my best interest and do what I would want you to do. And there are serious legal consequences for breaching those duties. So I've had people very confused and thinking that, I signed a power of attorney, I named my brother, now he won't let me move out of the house and he's controlling all of my money. And the answer is no, it's not a guardianship, okay? There's no court, there's no judge dictating what you can and can't do. You can always revoke a power of attorney. So the reason they're important is you don't want to have to go to court. The last thing you want is one of our judges in Fayette County or Scott County or any county in this area dictating how you live your life, where you live your life, what medical treatment you do and do not receive. And oh, by the way, you have to pay for the entire ordeal. So you've got to pay the court costs, you've got to pay all the lawyers that go to court, and you've got to pay your guardian once a year for just being the guardian. So it's something that we want to avoid at all costs, and the only way to avoid those is to have a good, durable power of attorney in place. That would be for the financial decisions, and also a healthcare power of attorney for the healthcare decisions. A lot of times it's the same person. But I've had clients that say, you for example, I was an occupational therapist, you're going to be the person who's making healthcare decisions for mom and dad. I don't want to make the healthcare decisions. Maybe I'm just the one keeping up with the bills and having to deal with the accountant every year and the financial decisions. So for brother and sister, it could get divided that way. Now, my normal operating procedure is if I have more than one child that are all trustworthy, I try to just include all of them. Because you never know when one's going to be out of town, in Florida on vacation, whatever the case may be. Name them all as long as they're trustworthy. That is the only requirement for a power of attorney, is you have to trust them as if you're giving them the keys to your house. You would never give somebody the keys to your house that you're worried about them going in when you're not home and stealing your silverware, right? Same thing with the power of attorney. Any other questions on all that?
So I need a power of attorney for when I can't make decisions for myself, correct?
Correct. Or even if you're just unavailable, Okay, so imagine you're in a car accident, you're in a coma. Obviously, you need a power of attorney. Or maybe you're in Florida on vacation and something's come up and you need somebody to sign a document for you who's in Kentucky. It's already there.
Okay.
Or, you know, what's more common with my clients, unfortunately, is dementia, okay? Memory issues. We're not as sharp as we once were. We need somebody who can step in and make important decisions when our mental capacity gets to the point we can't do it on our own. So that's the more common, but there can be a bevy of reasons why you would want one.
Okay.
Yeah.
So when I have an appointment with you,
Mm-hmm.
what documents do you usually recommend?
Are you saying when you come to the appointment, what should you bring, or
No,
what are you
why,
asking?
why am I even coming to see you? Where do I begin with my estate planning if I'm in my 60s and it's time to do some planning and I make an appointment to come see you?
So if you're over the age, if you're retired, let's put it that way. So some people retire 62, 65, somewhere in that range. If you're retired, you've got gray hair and nice shoes, you need, there are standard documents that I say everybody needs this no matter what. And a lot of my recommendations are going to be dependent on your specific situation. Do you have children? Do you have money? You know, what are we protecting? A lot of what I do is, we call it asset protection. Well, what assets do you have that we're trying to protect? You know, if you don't really have any money to protect, then there's not going to be an issue. You're still going to need some documents. If you have nothing to your name, you still need a power of attorney. You still need a healthcare power of attorney, and you probably just need a will just to make things simple. Okay? But a lot of people misunderstand. We all have a will. It's called the KRS intestate statutes. So even if you don't have a will, you actually do have a will. It's written in the statutes for Kentucky law. When you would need a different will is when you don't agree with whatever the Kentucky statutes say. Okay, so the Kentucky statutes say if you're married, you pass away, half your stuff is sent, this is in general, half your stuff goes to your spouse, the other half goes to your children. Okay? If you want to leave everything to your spouse, you need to have a will. If you want to leave everything to your children, you need to have a will. If you want to disown a child, or maybe you've got a disabled child, or someone who can't be trusted with money. Maybe they have a drug addiction or alcohol problem or gambling, you name it, and you don't want to just give them money. Maybe they're already disabled drawing government benefits. If you die and leave them a pile of money, you've just knocked them off all of their benefits, and you're actually hurting them by leaving them money. So there's a million reasons why you want to do documents differently than what the state already has set up for you. But if you don't really have any property, the POAs are going to be the most important thing to do. Now, most of my clients have some property. My typical client owns a house. It's usually paid for. If there's a mortgage, it's a relatively small mortgage. They've got some money in the bank. They might have an IRA or a 401k, and they might have a little bit of life insurance. 1 or 2 cars. That could be just a prototype client. You know, total net worth $500,000 or less. So it's not like you have to be a millionaire to derive benefits from the planning that we do for asset protection planning. And one way to think about it, sometimes the less you have, the more precious it is to you. If all you've got's a house, it's paid for, it's really important to you that you want to leave that house to your children. Not have to sell it and give all the money to a nursing home or medical bills or whatever the case may be. So in those scenarios, we're typically doing asset protection trusts that are designed specifically for the person who does not have a estate inheritance tax problem. So currently the federal is, depending on when somebody's watching this video, the current estate tax exemption is under 14 million, 13.75 million, something like that. I don't have very many clients that have to worry about that. So, if you do have that problem, that's a different conversation, and it's a different type of trust. But for everybody else, myself included, we're not worried about estate taxes because we want to leave things to our children or our grandchildren. And in Kentucky, there's no taxes on that money until you get above $14 million. So you can just figure my typical client's going to walk out with a asset protection trust, a will, a POA, a healthcare POA, and usually a deed where we deed the house into the trust. And that would be 90% of my clients.
Okay.
It's a long answer for a short question. So.
And how does a client avoid probate?
Well, the first thing, if you want to avoid probate, you have to define what a probate is. So probate is where you go to court and you probate your estate, but it's only your probate estate that goes through court. Right? So it's kind of a circular answer. Your probate estate is anything that's in your name when you die, in your name only, that doesn't pass via death beneficiary, or it's not jointly owned with a child or with a spouse. For example, almost every life insurance policy has a death beneficiary. That's not part of your probate estate.
Okay.
So no matter what your will says, you say, I want to leave my life insurance to my boyfriend and not to my husband. It's got to be done with the beneficiary designation,
Okay.
not the will, because it doesn't go through your probate estate. Now, automobiles are typically titled in one or the other spouse's name. So if we're going to avoid probate, that's something we have to look at quite often. Make sure we've either got it in both of their names or we've already signed the title, so that when you pass away, we don't have to open a probate in court just for a car that maybe is worth a couple $1,000s, like, well, the attorney's fees equal what the car's worth. We got to go through all this trouble, all because we forgot to sign the title before somebody passed away. If you're married, 99.99% of the time, you own your home joint with rights of survivorship, which means it is not a probate asset. It does not become part of your probate estate.
Okay.
So the will has no say over it. So if you own the house maybe before you got married, and you want to leave the house to your daughter when you pass away, if your husband's name is on the deed, it doesn't matter what your will says. That property is going to go based on the deed, not based on your will. So it's a problem that I run into sometimes, people not understanding that some assets are going to pass pursuant to how they're titled, whether or not there's a beneficiary designation, and you can't just write a deed, you just can't write a will and change that.
Okay.
Because it passes by operation of law based on these other scenarios. So I can't remember what the original question was. Something about how do I avoid probate?
Yes.
Short answer, make sure everything you own is in a trust before you die. Make sure you've signed all of your titles. If you have a checking account or a savings account or a brokerage account or a money market account that's in your name only, do a POD. That's pay on death.
Okay.
That's just like a beneficiary designation. Okay? You can either name the trust or you can name whoever, all the children equally, or whatever you want to do. But you have to fill something out, or else it will automatically default to your estate. And now we've got to open a probate for 6 months. We've got to go to court at least twice, sometimes 3 or 4 times. We might have to get an insurance policy, which is what they call a bond. It just can be a total big hassle.
Okay.
And it's always better to avoid it if at all possible.
Excellent. That was very helpful.
Well, thank you.
Thank you.
Is that all your questions?
I think that's good. I think we're good.